Um, okay. First things first. Good afternoon, everybody. This is Christopher Harris versus Crystal Harris and others. And this is 2021cv346415. Today is April the 19th, 2022. I am hearing this matter from Chambers. There is a jury trial in a criminal matter taking place in my courtroom. So in order to satisfy our very solemn obligation to make certain that the public's business remains open and accessible to it, I put this on our court's YouTube live stream channel. So currently we are on YouTube, and I will take us off that channel live stream before or as we conclude the hearing today. We are on this afternoon for a pretrial conference, and I'm here to bring you what I hope you will see as the happy news that you are specially set first out on our May 2nd trial calendar. So before we go on to talk about the actual pretrial order itself, I just wanted to let you know that day one, so May the 2nd, will be the selection of the jury, which in civil cases occurs via Zoom. So we'll give you all of the information. You have to, we'll pick the jury, and they will appear panel by panel on Zoom. We'll pick the jury from in that method, and then whoever is selected for the jury will be notified to actually physically come to court on Tuesday the 3rd. And then however long it takes us to try the case, it takes us. And so I hope that's good news. You certainly will be well aware of what your obligations are. And as I said, it's specially set, you'll be first out. So if we need to talk about the leave of absence issue, we certainly can. But this matter has been on a published trial calendar, and I'm pleased we can offer it at the beginning of the month and go ahead and get it taken care of. That would lead us next into talking about exactly what is in our pretrial order. And Ms. Gibson, you want to start us out?
Yes, Your Honor. The estimated time required is going to change. Initially, I thought it was a bench trial before Attorney Arrington filed a notice for jury. So that would lead me to 1 to 2 days as far as evidence. And I also had pending a motion for temporary restraining order. That issue is kind of moot since we're going to be having the jury trial. I thought if it was further on down the line that we would have run into some issues with the mortgage. We also filed an amended complaint for dispossessory, and that is dependent on the court's order on the universal default, which we would like to have tried at the jury trial. And since dispossessory is a summary proceeding, it can be tried on an expedited basis. And so those are the issues that we had.
Okay. So number one is, I understood the mootness of the TRO order on the universal default. And then finally, you said you had amended the complaint to seek a writ of dispossession.
Yes.
Okay. All right. Well, I would anticipate obviously getting the jury's verdict, and we can either hear it then or make some adjustments when we know what the jury's verdict is. Anything else? And then I'll ask Mr. Arrington. Okay, Mr. Arrington. issues you see pretrial or with the pretrial order?
All right, Judge, I'm gonna have to try to pull it up. My issues, I guess, are more personal than anything. Obviously, as the court knows, there's an election that starts on May 2nd with an election day of May 24th. I certainly guess since this is specially set, I will have to be available, but I don't even know if I can provide effective assistance of counsel on May 2nd or May 3rd or any time between now and May 24th. I'm absolutely preoccupied with my reelection campaign. So nonetheless, you know, there's already the default. The court did not allow us to open that default on behalf of Universal. And so Universal has the default. And I guess it would just be come down to who the jury believes, the plaintiff or the defendant. I think I'm gonna have to probably subpoena some records and maybe subpoena some witnesses for the second and the third.
Okay. Okay. Mr. Arrington, I obviously am deeply sympathetic. My problem is simply I don't get to pick when I get juries. I get juries totally candidly, we in the Superior Court, we get juries at the generosity of the state court, who lets us have every so many juries because they're getting civil juries and can't use them all. So I get one a month, and it's just your time. And I trust this case can be handled certainly effectively, but the plaintiff seems determined to handle it within a given time frame. In other words, I'm not going to say fast, but that's a modest announcement for a case that's been going on this long, and I trust you can do the same thing. And again, I'm happy to bench try it, but something's going to happen on May the 2nd. So in terms of subpoenaing documents and witnesses, I trust those are all in your pretrial order, at least named and anticipated, and that you're ready to go.
Judge, I frankly have not had an opportunity. We got something in. We got plaintiff's copy the day before it was due. I was in a trial all day that day and had commission meeting the next day. So I got something in, but I have not had the time to amply respond or prepare to anything right now. I'm just coming off of my law office being firebombed. And so I just have not had the opportunity to properly prepare for this or frankly any other case.
Okay. Okay. Now, in terms of time, and Ms. Gibson, you said 1 to 2 days, so I'm going to assume that's just for your presentation of your case?
Yes, Your Honor.
Okay. So any ideas, Mr. Arrington, as to what you'd be looking at in terms of a defense? Day, 2 days? I mean, it sounds like we can finish it within the week.
Yeah, I would say 1 to 2 days, Your Honor.
Okay. Okay. We'll be efficient. And I think after pending this long, we certainly know what the issues are. Anything else we need to address right now in terms of the issues to be tried? I hear Ms. Gibson saying, look, if we win, we want possession of the property, and we'll deal with that. That's not insignificant. But I do think at this point that may be that's an amendment, and that's there, but it may be putting the cart before the horse a little bit here. And I'm assuming we've exhausted all efforts to settle it. Is there anything I can help with? Does the son want the house, Ms. Gibson? Or does he just want it out of the?
Yes, we are going to, if we are successful, sell the house, and then whatever monies can be recouped will be placed back into Cleophas Harris's account.
Can I say something, Your Honor?
Oh, is that Ms. Harris? No,
Yes, it is.
No, talk to your lawyer. I'm not preventing you from talking, but I think it's always wise when you have counsel to talk to your lawyer before you say something to the judge. Okay. Any interest in any further conversation, Mr. Arrington, on settlement front?
I mean, I guess I'm certainly open to talk about settlement. I think the court there was a deadline for mediation, which I think is after our court date or maybe right before the court date. But is it possible, I guess, to enter a breakout room with my client to hear what she has to say?
Sure, we can do that.
Thank you, Your Honor.
Can you, oh, all right. Now, I'm probably going to accidentally invite everybody, so only Mr. Arrington and Ms. Harris go in there. Okay. Maybe. Okay, I think y'all can go in there now. And I'm gonna click off for just 1 minute. Hey,
Thank you, Judge. I spoke with my client. I don't know that we have anything here today. I guess maybe if the court could maybe give me through Friday to relook at the pretrial order and see if there's anything that I need to add. I don't know at this point what is and is not in there, but if the court would allow me at least that opportunity, I can try to focus in on this over the next couple of days.
okay, well, what I can do is this, and I think this will be fair to everybody. I'm going to go ahead and enter what we have gotten as the two pieces of the pretrial order. That doesn't necessarily make it very consolidated. Unless, of course, now I will say, Ms. Gibson, if you want to take another crack at consolidating everything, that's fine. But otherwise, I'm going to take the two pieces, and then any amendments, I will pledge to be receptive towards amendments. But the deadline for the pretrial order has come. I've got two pieces I can put together. And the only way I know to get this case resolved is to try it. At least put it on one of the very, very limited opportunities that we have for a jury. And we wanted a jury in this case, so it's going to be tried. And I'm going to enter the pretrial order, but I will be very receptive to amendments that you want or need. So that's number one. Number two, I think there's a request for the father to be by video, which to me sounds reasonable, as long as he's available for both sides. Number two, I do want to just take a second and describe for you what our jury selection process is, because again, I want to make sure we will send you careful instructions about getting onto Zoom. I will be here in the courtroom. It might be helpful if the lawyers were here in the courtroom with me, because then all of our technology becomes very, very easy. However we decide to do it as far as jury selection is concerned, I want to make sure everybody knows that on Tuesday, May 3rd, we start in person in the courtroom, just like a real trial. And the jury, of course, will be in the jury box in person that day. The only thing at this point that I think would change is if for some reason you wanted to go with a 6-person jury rather than a 12-person jury, that would go faster and it would be a little easier, but that's entirely up to y'all. You are entitled to a jury, and a jury we will have for you. But again, I want to make sure you understand that you personally have to come, and it's probably going to be best just from a technology standpoint for everybody to be here that Monday. I don't think it'll take us long to try to pick the jury. They'll be ready to go. Jessica, they'll be ready at 10. Yeah. They'll be ready to start questioning at 10. And so we should have, 30 people qualified by noon easily. You'll have the rest of the day to get prepared, and then we'll start first thing Tuesday morning. So I think at that point, we got a pretty straightforward case. Anything else? Ms. Gibson, I can't hear you.
I'm sorry. I have my client, Christopher Harris, his sister, Catherine Harris, and Cindy Harris. They all live out of state. Can I file motions for them to testify via Zoom? I know Christopher Harris is primarily responsible for the caretaking of his dad.
Ms. Gibson, that's up to you. I'm pushing the defendants as hard as I can, despite the desire not to try this case on May 2nd. And again, I'm sympathetic to a lot of that. So Ms. Gibson, you're the plaintiff. It's your case to make. There are rules about appearances by video, especially set in this case. If you and Mr. Arrington can agree to presentation, but I'm going to definitely do video for the dad. But as far as out of state witnesses are concerned, that's kind of by agreement with you and Mr. Arrington.
Okay. All right, I'll reach out to his office.
Okay. I think that's the rule. I think the uniform rule is that if either side disagrees or does not consent to the Zoom or video conference appearance of a witness, the procedure is either you agree or the non-agreeing side gets a continuance, and I don't think you want that here. So I'd have them teed up to come in person.
Okay.
Or we can do the whole thing by Zoom. That's up to y'all. We can't do a jury by Zoom.
Right.
If you want to do bench trial and do it by Zoom, again, I'm happy to do that. If you want to remain with the jury, then I think everybody's going to need to be here.
Well, I mean, Mr. Arrington filed a jury trial demand, so
I understand.
if
I
he
know.
wants to change it now, since that he knows that it's going to go May 2nd regardless.
Well, he's the one that filed the jury demand. If he wants to withdraw the jury demand, we've got a bench trial. So,
Right.
I mean, again, we're talking about strategy here. I can offer you either one. I think everybody's just,
Mr. Arrington, you made the jury demand. Do you still want to proceed with a jury trial?
Ms. Gibson, I'll be available to talk to you to discuss the matter afterwards. If you want to, I can give you my cell phone number.
Okay. Well, I don't want you to give it to me on YouTube. So,
no, you can give it in chat, and then I'm going to take us off YouTube in just a minute.
mhm. Okay, I have it.
Okay, so yeah, I mean, I'd be happy to discuss that question and I guess the case in general. And I don't know what time is good for you, but I'm available the rest of the day.
Okay.
Okay. Well, listen, we're gonna get two pieces of this order filed. I will be amenable at any time anybody wants to ask that it be amended. We'll start the jury on May the 2nd. We'll send you links for that, and we'll get the case tried. And I'm not trying to be a Pollyanna about it. I just think this is the thing to do for everyone's sake. Okay, if there's nothing further, I'm going to take us